Hi, everyone. Welcome to another episode of Coffee Time with the business law lawyers at Robbins Appleby. Today, we'll continue on with our return to work dialogue. With most of Ontario now proceeding with phase three, more and more businesses are reopening their workplaces again. So today, we'll discuss what happens if an employee refuses to return to work, or if they do return to work, what happens if they refuse to follow the employer's policies relating to COVID-19. With us today, as always, we have Jonathan Zepp,
Hey, Charlie.
Ishmael Ibrahim,
Hey, Charlie.
and Nathan Holloway.
Hey, Charlie.
Hey, Ishmael, I like the mug you have there.
Yeah, number one uncle. Rightfully so.
Very nice. Lucky nephew.
So my first question is to Ishmael. So Ishmael, what happens or what rights do employees have for refusing to return to work once the employers open up their workplaces again?
Well, aside from the request for accommodation discussed in our last session, there are really two scenarios where an employee can legally refuse to return to work. The first scenario is that an employee has a right under the Occupational Health and Safety Act to refuse to work where they have a reasonable basis to believe that the performance of their job duties represents a danger to their health or safety. However, this isn't a right that's merely exercised in the sole discretion of the employee. There's a process that must be followed. Generally, the process works this way. The employee must first report the refusal and reason for refusal to their supervisor. The employer at that point has a chance to address the concern. This must be done through an investigation by the employer, usually in conjunction with either a member of the Health and Safety Committee, a health and safety representative, where there's no joint health and safety committee, or another worker because of their knowledge, experience, and training that has been chosen by the worker or by their union to represent them. So following this investigation, the chance to address the issue, if the issue is still not resolved, either the employer or the employee can still go and call the Ministry of Labor to investigate. The inspector then investigates and provides their decision, and this is binding on both sides. Whether or not an employee's belief regarding the safety of the workplace is reasonable will depend on many aspects. The nature of the workplace and the safety safeguards that the employer has put in place. And the employee's individual circumstances will also matter. With respect to COVID, what is publicly available information will likely be very relevant in that determination.
So what about the second scenario that you mentioned?
Well, as mentioned in our last coffee time session, the second scenario is that an employee can request an unpaid leave through the infectious disease emergency provisions of the Employment Standards Act that were recently enacted. Here, the employee can request unpaid leave if they cannot perform work for the reasons related to COVID, which include reasons related to the employee directly or reasons related to the employee's obligations to family members. It should be noted, though, that this option only exists as long as COVID is considered an infection under the ESA, which it currently is.
So what happens if employee doesn't return to work despite the workplace being safe, or the employee doesn't want to seek unpaid leave, or is otherwise just not entitled to unpaid leave?
So I'll jump in there, Charlie. So this is essentially an accommodation question. So as mentioned in our last session, accommodation is a case-by-case assessment. But if an employee refuses to return to work because of a fear of contracting COVID, then in the absence of any leave entitlement, any justification for accommodation, and after any Occupational Health and Safety Act concerns have been addressed or if none arose in the first place, then the employee must return to work. Otherwise, it could be considered a willful neglect of duty or willful misconduct under the Employment Standards Act, which would allow an employer to terminate the employee without termination pay or severance pay. So this is obviously something that both employees and employers should be aware of before making this decision not to return to work. For employers specifically, it needs to be remembered that willful neglect is not actually defined in the statute. and therefore must be considered on a case-by-case basis on the specific facts of the specific employee. So it's not necessarily the case that you can just look at the past experience with one employee or past cases and say, well, that happened here, so therefore it applies in my case. And the other thing that employers have to remember is that just cause under the ESA might not actually be just cause under the common law. So employers have to look at their employment agreements to understand where their liabilities may lie.
So then how do you determine willful misconduct?
So where the basis of the misconduct is a failure to comply with a rule or a policy, which would be the case here, the OLRB has held in a decision called Martin Pet Foods that the employer must satisfy the following criteria. So one, the rule must be clear and unequivocal. Two, the rule must have a substantial bearing on the employment relationship. Three, the rule must have been communicated to the employee. Four, the employee must know or ought to have known that conflict with the rule would result in termination. And five, the rule must not require the employee to do anything which is illegal or unsafe. So four of those elements are pretty easily satisfied or would likely be satisfied in many cases. And the one that it comes down to is whether there's a substantial bearing on the employment relationship. So the board doesn't actually have a lot of discretion to assess the reasonableness of the rule. And so as long as the rule has a substantial bearing on the employment relationship, then an employee who disobeys that rule may be considered to have engaged in willful misconduct. But for employers, they have to remember that misconduct or neglect of duty needs to be willful. So it's not just simply enough that the employee is indifferent or casual or thoughtless in respect of the rule and the performance of their duties or the failure to perform their duties. The employee must have made some conscious and deliberate decision and have made some positive act of misconduct or deliberately refrained from performing their duties or complying with the rule.
Okay. So you mentioned that the rule must have a substantial bearing on the employment relationship. So would an employee wishing to work from home as opposed to heading back to the office meet this criteria?
It really depends, and employers need to remember that it's not necessarily a black and white question. So, but in a decision called Pereira and Business Depot Limited, it was explained that there's an implied term of every employment contract that the employee attend at work, and that the employee is only excused from this obligation where they are unable to report to work, or they have the employer's permission not to come to work. For example, if they're sick and they've called in, the employer is okay with it. And then, so the presumption is likely going to be that attending at the workplace is going to have a substantial bearing on the employment relationship. But then you have to consider the COVID situation. So for certain jobs like mechanics or dentists, it's obvious that showing up to work is going to have a substantial bearing on the employment relationship because the duties of those employees can't be carried out at home. So a dentist can't carry out a dental procedure in their own home and needs to be in the office. But for other employees like office workers, we've seen over the last 3 or 4 months that much of the work can be completed at home and completed at home well. So in these cases, the argument of the employer might not be so strong that there's a substantial bearing on the employment relationship in the employee attending at the workplace as opposed to working from home.
What about abandonment then? Can an employee that refused to show up to work be considered to have abandoned their employment?
Well, in order for an employer to terminate an employee for job abandonment, which is considered termination for just cause, the employee's intentions to abandon their position must be made clear. As with most just cause arguments, the lines are somewhat blurry. There's no specific length of time stipulated within the employment legislation in Ontario that constitutes job abandonment. The test for abandonment is similar to the test for resignation. That is, the statements or actions of the employee, viewed objectively by a reasonable person, of course, must clearly and unequivocally indicate an intention to no longer be bound by the employment contract. Abandonment occurs where the implied term of the contract is breached by the employee. Abandonment demonstrates an intention to no longer be bound by the employment contract and therefore constitutes a repudiation of the employment contract by the employee. In these circumstances, the employer is then entitled to accept the repudiation and treat the contract to being at an end.
Wait a second. So Ismail, we're talking about abandonment. It means that the employee has to clearly and unequivocally indicate their intention to no longer be bound by the employment contract. But under COVID-19, aren't we expecting that the employee wants to return to work? They just don't want to return to the workplace.
Well, Jonathan, there's no easy answer for that. As discussed earlier, the presumption is likely going to be that if the employee refuses to show up to work, and assuming that all other aspects of the return to work request are justified under the law, then the employee could be considered to have abandoned their position. In these cases, an employer would be justified to terminate the employment for just cause. At the same time, the X factor here, as you indicated, is that an employee that can work from home may be able to argue that they never had an intention of resigning. Thus, they never abandoned their position in the first place. We think that this is going to be very fact specific, and that employers need to be very aware of the potential risks before terminating the employment relationship.
Yeah, and we saw, from Nathan's discussion of the Pereira case that the court does recognize that being at the workplace is an important element of employment. And look, employers do have, and employees do benefit from being at the workplace. First of all, office culture is created by people being there. Many projects require teamwork, and of course, teamwork is better when people are together. And being together with other people allow for a better exchange of ideas and a better flow of those ideas into work product.
So those are really good points, Jonathan. Just switching gears a little bit. So what about employees that do show up to work but refuse to follow these safety policies related to COVID-19?
So Charlie, here we're talking about the laws of insubordination. So insubordination in the employment context is defined when there's an intentional refusal to obey an employer's lawful and reasonable order. It's fundamentally implied within the employment contract that the employee must obey the lawful and reasonable instructions of the employer within the scope of the employment. In a case decided by the Ontario Superior Court called Daniels and Canadian Gift and Tableware Association, the court found that whether the misconduct complained of was an act of insubordination, or an employer's breach of policy, or a failure to adhere to the reporting structure, for example, going over the boss's head, it must amount to such a repudiation of the employment contract to be an essential disregard of the terms of the employment contract. So an employee commits a major breach of an important term of the contract. That's insubordination that warrants termination without notice. Essentially, each case, though, will turn on its own facts, and each fact, whether you can terminate for just cause or not, will be important based on the context. So generally, there's a fairly long list of elements of insubordination, but generally, I would like to distill them into kind of four general points. So the order that's given by the employer must be clear and specific, and it must be a breach of a policy or procedure known to the employee. So the employee needs to know that they need to comply with these policies. Secondly, the order must be within the scope of the employee's job duties. Thirdly, the order must be reasonable and lawful, and it must involve a matter of importance. Lastly, the disobedience must be deliberate and intentional rather than resulting from an honest mistake. The employee can't, for example, not realize that the order is in effect, or perhaps they didn't even realize that they weren't complying with the order. They must know that they're disobeying the order.
So then, can an employer immediately terminate an employee for not following lawful and reasonable policies?
No, the law is more nuanced than that. You really, first of all, the employer must warn the employee first. In the Daniels case, the court said that there's modern jurisprudence which says that the employer must first warn the employee that his job is in jeopardy for not complying with the order, or his or her job is in jeopardy for not complying with the order. And secondly, the employee must have a reasonable opportunity to correct the behavior. The judge did warn that there are some conduct or misconduct which could be particularly serious, which could warrant termination without notice.
So I guess the question is really about the seriousness of not complying with COVID-19 related policies then.
And look, there's no case law to let us know whether complying with COVID-19 policies are serious enough to warrant termination of insubordination without notice. But I think we have to look at other case laws. So we know in Canada the examples of where you're entitled to terminate for just cause without notice are fraud and theft. Other elements where termination with cause or for just cause occur are really actually much more nuanced, and the court has really shown that they favor a more progressive discipline approach. So, for example, in the case of Bagnall and Calvin Klein Cosmetics Limited, the employer had a basic duty of fairness to the employee, and how that was exercised was that the employee should have been given the opportunity to correct the mistake. Well, how does that happen? First of all, the employer needs to give the employee information about what they're doing wrong. They may even need to give the employee assistance on how to correct that behavior. They have to explain to the employee why the employer is unhappy with the behavior. Also, they have to understand how the problem might be corrected. So the employee needs to have kind of a roadmap to better conduct. And lastly, the employee needs to understand the gravity of the matter, and that if they fail to comply with the employer's order, the termination may result.
Yeah. Well, this was really great, gentlemen. Thank you again to Jonathan, Ishmael, and Nathan for your insight. I just want to leave off by providing some departing word of wisdom for our employers out there. So point number one, employers should be aware that they have an obligation to make inquiries and communicate with the employee before presuming that the employee has abandoned his or her employment. The second point is that in communicating with an employee who's able to work, you have to provide a clear date of expected return to work and identify the consequences of failure to return to work. The third point is to document all communications, including attempted communications. And lastly, you have to prepare and implement attendance or absence policies that both define the attendance expectations and permitted absences, and establish a clear expectation for communications with employer and any supporting information that substantiates a basis for the absence. Well, I hope that all of our viewers will find this resourceful as they navigate their way back to the workplaces. And please make sure to tune in for our next episode of Coffee Time, as we'll be discussing both the termination and non-termination options that are available to their employers in dealing with their employees, as well as some of the considerations for changing the terms of the employment relationship, both during the financial crisis now and potentially beyond. We'll see you next time.
So long, Charlie.
Thanks, Charlie.
Bye, everyone.